pleasure to kick off this evening event with the first talk with Professor Stephen Freeland. He's Emeritus Professor from Western Sydney University and a Professorial Fellow of Bond University and a co-founder and co-principal of Azimuth Advisory in Australia. Stephen, it's a great pleasure that you are here with us today. We appreciate so much your dedication, commitment to us, to the Austrian National Point of Contact, despite your numerous tasks now as the co-chair of the scheduled informal consultations on space resources. It must be a very exhausting time for you during the legal subcommittee, and we really highly appreciate that you take the time for this talk for our evening event. Why we had the idea and then dared to ask Professor Freeland, despite his numerous tasks at the moment, to participate in this event is that he has been advisor to the governments of Australia and New Zealand when they developed or reviewed, respectively, their national space laws. And the trigger of these two laws were indeed launch services, so the development of the space launch sector in Australia and New Zealand. And so we thought he would be the perfect person to talk about the private and public aspects of space launch services and their role in the development of national space law and policy. Stephen, it's really a great pleasure to have you here. And I would like to start with a brief account to the two first questions which we shared with you and also the audience about the topic. Namely, first, please describe briefly the space sector you will talk about. And second, to what extent is this sector private or public? Stephen, the floor is yours.
Oh, hello, Irmgard. Thank you so much for that very generous welcome. Hello, everybody at the Legal Subcommittee. Perhaps you're already sick of my face, so this is being pre-recorded, and I understand there's an interested audience in this wonderful event that's being organised by the National Point of Contact in Austria, and I congratulate them. It's a really great idea to focus on these industries and see the interaction between real activities in space and the regulation. So thank you for inviting me. When you're watching this, everybody, it's probably about 2:30 in the morning in Australia. So Irmgard very kindly and mercifully agreed that we could pre-record this rather than me being there live. So I say hello to everybody from Australia. Before I start, let me acknowledge the fact that where I am sitting here in Australia is land where people have lived for 65,000 years. That's over 2,500 generations of people. Our Indigenous people in Australia are renowned as almost being the world's first astronomers and have great knowledge and wisdom and experience with space. And those lessons are important for all of us to learn. And I'm sure that's the case with Indigenous people around the world. So thank you, Irmgard, for inviting me. Yes, I'd like to talk about launch services, because as you say, in the case of Australia and New Zealand, two of the governments that I've had the honour of helping and working with, amongst others, in the development or implementation of their national laws, for those two countries, the impetus for their national law was in fact launch services. So let me perhaps briefly outline why that is the case, why are launch services so important, or perhaps more relevantly, what questions are relevant when one considers firstly whether launch services are appropriate for a country. And then secondly, in the answer to those questions, that will feed into perhaps how the national law might look. So I've got on this slide here a couple of fairly fundamental and basic questions. Launch services, of course, the demand for launch services continues to increase. It obviously is something where safety is of primary concern because, of course, launching and then also in the case of Australia, returns, particularly times where things could go wrong. And we've seen, unfortunately, that happen a few times over the years. So there are a couple of sort of basic fundamentals that are important for any country that is considering the development of an indigenous or sovereign capability for launch services. I use that expression sovereign capability because that's something that increasingly we are hearing in various countries in these times, particularly, for example, in Australia. Now, there is a great debate about having the capability for sovereign capability in launch. New Zealand, and I'll explain a bit more, already does have that capability. And as I said, in both cases, the law was promulgated as a result of that. So what are these criteria? Well, obviously, as everybody is aware, the geographic location of a particular launch site is important, depending on which orbit one wishes to go, whether it's geostationary, whether it's polar orbit, whether it's low Earth orbit or other orbits. So obviously, that's a fundamental first point. Where is the proposed site located? That's also important in terms of safety. And you'll find typically, certainly in New Zealand and the proposals in Australia, if they do go ahead, the launch sites are where the launch vehicle would essentially launch over water and away from any populated areas, and for obvious reasons. So that leads on to the second bullet point there. What other necessary requirements do you have? Particularly to attract, once you've got the launch service capability, attract overseas companies and perhaps even overseas governments to also utilize your services by launching their satellites from your facility. So clearly you need things related to the stability of the country, the infrastructure, the language, the fact that things work, transport systems working, quiet skies, as I mentioned, one in terms of not flying over populated areas, but also having areas where, as much as possible, there is very little air traffic. And obviously, also, it would be important to launch from a country which understands space, understands the industry, has its own infrastructure in place, has its own knowledge to deal with various contingencies, and also has an enabling legal framework in terms of import controls and export controls in terms of the infrastructure. So I've mentioned the fact that sovereign launch capability is important. In the times that we live in, increasingly space is seen as part of the absolute critical infrastructure of any country, not only for national security reasons, but for economic reasons and for the civil society reasons, and allowing the economy to prosper and develop and actually function. And so sovereign capability in terms of launch is seen in these times as being an important element to various countries in the way they develop their capability, to allow them further independence in perhaps utilizing space for their particular needs. Obviously, that's important for engagement in space. That's important for national security interests, but it's also important in developing the local, indigenous, national space sector, because where you have launch service capability, there are many other additional capabilities and skills that are developed through necessity to undertake those activities. And of course, other types of space activities will piggyback off that. So there are a whole range of reasons why launch services are important, but not every country either desires to have it, needs to do it, or in a sense is able to do it, given that there are various requirements that really make it feasible. Once one wants to undertake launch services, then obviously the regulatory framework is important. The regulatory framework is important for all of the reasons that we know under the space treaties in terms of implementing obligations under the Outer Space Treaty and the other UN treaties, to be a good international citizen, etc. But it's also important in the scope of launch services to ensure things like safety, which is incredibly important when one has a launch service activity, in terms of ensuring that the technology that's being used is appropriate, is tested, is safe, is transparent in terms of the types of infrastructure and technology that's being used. So one needs to ensure that the regulatory framework in the national system is compatible with, is enabling, but also is rigorous to ensure that the activity is carried on safely. Because of course, the last thing we would want, and certainly the last thing any country would want, would be to have a launch service disaster, an accident, because of the potential for loss of life and damage to person and property. And so all of these factors are really important. So the regulatory framework, and I'll come back to this a bit later on, Irmgard, if I may, really has to balance some factors. So I'll talk about Australia and New Zealand. I've had the pleasure of working with other governments as well in their national laws, but we'll concentrate today on Australia and New Zealand. In Australia, we don't yet have a launch service capability, but there are a number of countries, I've named 3 of them here, that are developing this capability, working with the regulators, working with the industrial and technical people to develop sovereign capability in Australia. Southern Launch, which is proposing to launch from South Australia into the polar orbits. Gilmore Space, which is proposing to launch from Queensland, and Equatorial Launch Services proposing to launch from the Northern Territory into geostationary and equatorial orbits. Those countries are still in development and working with the regulators. We've had some test launches. Of course, Australia has had in the past Woomera, which still operates, and Australia was, ironically, probably the 3rd country in the world that launched its own satellite from its own territory way back when, from the Woomera range in South Australia. The Woomera range still operates, but is now protected area controlled by the government and controlled by our Department of Defence. And so the 3 companies I've mentioned there are private companies, commercial operators who are seeking to develop launch facilities and offer these services. Clearly, they work closely with the government, but they are private entities. They are supported by the government by way of grants, by way of regulatory support, by way of licenses ultimately, but they are private entities seeking private capital to develop. New Zealand, everybody would be aware, has already sovereign capability. A company called Rocket Lab is launching from the Mahia Peninsula in New Zealand very successfully. It's launched dozens now of successful launches, concentrating in small satellites going up to altitudes of, I believe, around 500 to 600 kilometers. So that's already operating, and the New Zealand law was designed around regulating that. Again, a private company, but clearly with governmental support in terms of the regulatory framework, in terms of infrastructure support, in terms of a whole range of issues. But you'll see, therefore, in both of these countries, the operators are, in the case of Rocket Lab, and will be, in the case of those proposed in Australia, private entities seeking private capital and competing in the commercial markets.
Thank you very much, Stephen. That was a great overview and insight into what's going on down under, so to say, in Australia, New Zealand, with respect to launch services, which we in Europe, are not so well located, Prof, according to your explanations. My next question would be, how were you involved in the development and review or review of the national space laws and policies? And what were the biggest challenges in this process?
Oh, that's a great question. And let me briefly tell you about the Australian experience and then the New Zealand experience. Because as I said, in both cases, they were driven by the idea of a launch services industry. So Australia was, I think, the sixth country in the world to have its own national space law. In 1998, we had the Space Activities Act. And that was legislation that was promulgated at that time because the government of the day felt, when there was interest from consortia, felt that Australia could enter the launch services industry. Indeed, at the time, one of the ministers said that perhaps by 2010, Australia could have 10% of the world launch services industry. That was a statement made by a minister at the time. And so the Space Activities Act was put in place. At the time, as I said, there were very few national laws in place. Irmgard, you know this very well, of course, because you are a leading expert on national law generally. And so the Space Activities Act was drafted with one eye on the then existing US law. And much of the US law that was relevant for launch was looked at and applied in an Australian context in terms of maximum probable loss, in terms of the amount of insurance required, etc. So the Space Activities Act was put together to develop a launch service industry with a sophisticated licensing regime for launches, returns, but also other licenses called, for Australian entities or individuals who wanted to launch from overseas. But in a sense, that was very much the secondary raison d'etre. The main thing was around launch. Interestingly, though, Gard, as I said, Australia has still not yet developed the launch industry. So the main driving factor for the Space Activities Act actually has not come about, which is quite strange. Yet the legislation was very useful for other companies, one of our large telecommunications companies, Optus, for example, which launched 6 or 7 geostationary satellites from various countries overseas. And so the overseas launch certificate, now called an overseas payroll permit under the new legislation, was utilized under the Space Activities Act. So the act was useful, it was helpful, but actually it wasn't used for the main purpose, which was launch. Then the Australian legislation, the Australian industry was changing, as was every country, with the development of different types of technology and particularly issues about miniaturization of space technology. So from about 2010 to 2015, the nature of the industry was changing. We still had those geostationary satellites, of course, but there are many smaller companies developing other types of capabilities. And the government of the day just thought that we need to review the Space Activities Act because it was for a certain purpose. Large rockets launched by large companies with big balance sheets, and the industry had changed. So they called on for a review of the Space Activities Act. I was honored. The government appointed me in 2015 to review the Space Activities Act, to make recommendations about how it might be amended to take into account the changed nature of the industry, the changed nature of the types of activities, the changed nature of the actors and other circumstances. So I reviewed the Space Activities Act, put in a report of about 180 pages, I remember, in the middle of 2016. The government took on board my review, engaged in some other consultation processes after that. I'd already had consultation, but this was an ongoing process. And on the basis of initially my review and then other processes within government, the legislation has been amended. It's now called the Space Launches and Returns Act of 2018, which came into force in 2019. It's still very much focused on launch. It's also focused on return, and as people will know, we've had returns. Hayabusa 1 and more recently Hayabusa 2, for example, have returned to Australia under the relevant legislation. It's about launches. It still has overseas payroll permits, but it's now designed, taking into account some of the recommendations I made, but other things that government had, to perhaps be a bit more user-friendly and enabling for the smaller companies with smaller balance sheets and the, for example, financial requirements for insurance have been decreased significantly from what they were in the original Act. So that's the situation in Australia. In New Zealand, as I said, it was slightly different. They had the launch capability, they didn't have the law. And so initially, New Zealand perhaps didn't aspire to be a spacefaring nation in a significant way. Rocket Lab, which it was an American company, the New Zealand subsidiary, and its CEO is a New Zealand citizen, came to the government, developed a launch facility, actually launched already in May of 2017 under contractual arrangements between the company and the New Zealand government, and there was also arrangements with the US government and the New Zealand government, but they didn't have legislation. So the government came to me already in the beginning of 2016, knowing that this was going to happen. And together with the government, I worked for 18 months in the development of their national law, which is called the Space and High Altitude Activities Act 2017, which came into force in 2017. So this was a reaction to launch. But I have to say, one interesting point was the initial brief was, let's draft and develop together with my assistance of the government, what they would call the Space Activities Act. But then over the period that we were working together, the government recognized that there were other types of technologies, high altitude platforms, pseudo satellites, drones, that were operating in what you might call high altitude, so above commercial airspace, but below what we might regard as space, recognizing, of course, that we don't yet know where the boundary is, but in this high altitude area. And so the brief expanded, and you'll see the New Zealand legislation, of course, regulates launch and has a really flexible and interesting regime in terms of the way it has licenses, but it also regulates high altitude activities. And I think that is a trend that will continue. Other countries will have to do that. And indeed, under the Australian amendments that I mentioned previously, they now also regulate what are called high power rockets, which are defined as objects not intended to go to space, but with particular functionalities and characteristics. And so slowly that trend under the quote unquote space law will also include high altitude. But again, this was driven by the need to provide launch services. So both, I think, interesting experiences, and we shall see as time goes on how they continue to encourage the development of the respective national industries.
Thank you very much. This is extremely interesting indeed. Also now the last part on high altitude regulation, which is ahead of us still in Europe and elsewhere, to discuss how the so-called suborbital activities could be regulated. Should they fall under the Space Act, or are they rather aviation activity? Probably not, but they are not space activity in the traditional sense either, because they do not complete one orbit, not even that, they just go high up and down. So that's really an open issue, and is challenging, and it's great to hear the experiences of Australia and New Zealand in this respect. And of course, we will look carefully at what Australia and New Zealand has done, also in other circles, so to say. My last question to you, Stephen, would be, what recommendations would you have for the future for other national legislators and policymakers?
Oh, again, a really great question. As I said, I've had the honor of working with quite a number of governments in the development or the review or the amendment of their legislation over and above Australia and New Zealand. And in the end, you begin by asking the same questions, but you get very different answers. And that's why The first point I would make would be that the national framework has, I'm stating the obvious here, but it has to suit the particular characteristics of the particular country. We know what some of the headings will be through the implementation of Article 6 of the Outer Space Treaty, for example, and other things under the international framework. So we know what some of the headings will be, but some of the specifics will differ from country to country. So recommendation number one is obviously make sure that your national legislation suits, is fit for purpose. And an expression that I've learned from government, although I don't like it, is perhaps flexible enough and what we might call future-proof. But national law is a balance. It's always a balance. It's a balance for on the one hand, all of the things I've mentioned: safety, international obligations, protecting the environment, implementing things like, for example, the debris mitigation guidelines and now the long-term sustainability guidelines, protecting the national interest. All of those things on the left-hand side of the ledger, incredibly important. But for some countries, and virtually for all countries, but perhaps to different degrees, there's also the desire to develop industry, to make the barriers to entry, particularly in this era of change technology and miniaturization of some technology, lower the barriers, because you're going to have smaller companies or different types of actors engaged in space. Having a licensing system that works, having financial requirements that works, having laws that point the way and then implement best practice and feeding that through and requiring that. Because my experience at the UN process is, of course, all of those best practices from national systems also feed back into the way that international law may be developed. So get the recommendations are getting these balances right. And it is a real challenge to get this right, to find the right answers, because sometimes you might think that some of these issues are slightly conflicting. I don't think they are, but it requires, on the side of government, flexibility, a clear focus about what it wants, understanding the technology is changing, ensuring that it implements best practice, but also being flexible in the way that, for example, it reviews its legislation from time to time. It takes into account, for example, the changes in technology. One example is the actual definition of launch. We all understood what launch was in the traditional days, but now we have space objects being, if you like, propelled into space, for example, from the International Space Station. And so you need to take into account definitional changes to take into account, is that launch and how does that fit into the legislation? These are legal questions, but they're very much required to be understood and put into a practical framework in terms of the national law. So governments need to understand the changes, be flexible, comply with all of their requirements, understand and take a global view as well as a national view in terms of the consequences of space activities and ensuring safety. On the industry side, particularly in the issue of launch services, because it's got a whole range of safety issues involved, I urge industry, and my experience is they must do this, to be very transparent with government in their plans, to speak with the regulators on liaise with them early on, to have good advisors who understand the law. And the law is not just the national space law. There are other there are other laws that will be relevant. For example, the import of space technology will require import controls, or exporting technology or services or whatever will have export control requirements. And there are other requirements that will arise under the particular country. So operators, industry, they are good at what they do, but they need to ensure that along with all the technological developments, they move along at the same time in speaking with the regulators and going and complying with the law and understanding what is required of them in terms of the way they carry out things, but also the information that they provide to governments, because governments are not going to approve launch until they are convinced that this is a safe activity, given the risks that are inherent with launch. As I said, it would be disastrous for any country for something to go wrong. So there are real challenges in terms of technology, information flows, the different aspects and the different considerations that don't necessarily coalesce. On the other hand, if you get it right and you have a successful launch service facility, that adds tremendously to the capability of the country. It adds to their ability to become more space savvy, more space independent. It offers services to others, so it allows for exchanges of technology, exchanges of services, for shared operation, for shared activities, for cooperation in the peaceful uses of space. So it's a really positive outcome, but there are many challenges and many things that we need to get right along the way. But in many countries, that's already happening. And I hope that all those other countries that are looking at their national law, either to review or amend or to develop, will take account of the fact that, it's not easy, but once you get it right, and once it is operative and works, not just for 1 or 2 or 5 years, although you should be reviewing, but ultimately is flexible enough with review processes for longer than that, then I think that will help develop an infrastructure in a country that will allow for cooperative, peaceful activities. So I hope that answers all your questions, Irmgard. And again, let me congratulate you for this wonderful event. I think I'm very excited, even though I won't hear it live, but I'm very excited to hear the other speakers. You've got some wonderful speakers talking about really interesting aspects, and I hope this little discussion that we've had is of interest to people, and look forward to any other questions offline from anyone who would like to discuss them further. Thanks.
Thank you so much, Stephen. This was really a great start of our event. A lot of thoughtful insight, and we have really to consider and discuss our discussion all of these many things. I thank you very much again. And now we will hand over to our live presentations. I wish you all the best and great success for your continuous work as a co-moderator during the legal subcommittee, which is still lasting until the end of this week. All the best to you and Andre. Bye-bye.
Thank you, Irmgard. Thank you for inviting me, and thank you, everybody. I hope for listening in, and I really appreciate the goodwill that I've seen throughout the legal subcommittee, and including in the scheduled informal consultations, the goodwill of all the delegations and member states, and that's a wonderful thing. Thank you so much.
Thank you.